Hi, my name is Shruti Khanal and my student ID is 20173479. This presentation is all about my assignment 3 of TAX 600. As this assignment is all about the case studies, talking about the Wicks versus Federal Commissioner of Taxation 25 January 2022, the issue in Wicks versus Federal Commissioner of Taxation was that there had been fraud in justifying the making of an assessment upon purported discrepancy being discovered between the assets of the taxpayer and the income returned by the taxpayer. As a result of this greatly vexed problem, there have been major inquiries in response to greater concern which has been expressed by the stakeholders and taxpayers that powers are not utilized judicially by the Australian Taxation Office ATO. As per the law, the Commissioner is not satisfied with the taxpayer's return and creates a default assessment. As a result, the taxpayer is unable to challenge the assessment's due making in administrative review. The sections breached in Wicks versus Federal Commissioner of Taxation include Section 170 of the ITA Act, where assessment may be amended by the Commissioner at any time if they opine that there has been evasion or fraud. Considering this, the assessment that had been amended in place in the same position for Section 80 was Schedule 1 to the TA Act as the original assessment noticed by Section 173 of the ITA Act's virtue. Allegations were made by the taxpayers that the exercise of the amendment power has been unauthorized since there have been no evasion or fraud and no evidence proving that there had been fraud or evasion. Notwithstanding the provision of the jurisdiction of Section 175 and Section 35010, the Commissioner is not allowed to create a ununiformed guesswork while making a default assessment. Through reasoning's parity, there needs to be a genuine attempt to ascertain the character of a discrepancy that had been subsequently discovered before invoking the amendment power in Section 170. In order to make taxpayers understand that the case will have a potential impact on the tax returns of the clients in Wicks versus Federal Commissioner of Taxation, the taxpayers need to follow certain recommendations. The taxpayers need to demonstrate on the balance of probabilities that there had been no emission of income and therefore no tax avoidance. Scancroger Lakes Private Limited versus Federal Commissioner of Taxation, 24th May 2013. In the case of Sanctuary Lakes Private Limited versus Federal Commissioner of Taxation, the taxpayers' appeals had been dismissed by the full federal court. According to the court, both the claimed losses has been of a capital nature and the taxpayers did not incur the claimed outgoing. The taxpayers' argument has been rejected by the court that it follows that the taxpayers along with its agent might have adopted reasonable care if it had a RAP. The Commissioner's appeal had also been dismissed by the court. The court considered the fact that the taxpayer possessed a RAP on the issue of deduction in dispute. According to Section 29820 of Schedule 1 of the Taxation Administration Act 1953, the court considered that the taxpayer had a RAP on the deduction problem in dispute. According to Australian Government 2013, this section has been provided to be unconfined in its term and it does not consider the fact of a RAP from exercising discretion in that section. On the other hand, the power under Section 29820 needs consideration of the taxpayer's particular circumstances. The fact that the taxpayers possessed a RAP concerning contractual provisions, constructions to which it had been a party, is a matter that relates to particular circumstances. The AAT acknowledged that favorable conditions were required to mitigate the taxpayer's failure to meet the level to perform reasonable care. ATO accepted the court's judgment and also acknowledged that the appropriate questions of the harshness of the relevant penalty reflected certain approaches that had been taken by the AAT in the case depending on the present circumstances to be considered according to Australian Government 2013. More ideas and knowledge should be developed by the certain person who are supposed to file tax deductions. They need to check on the performance regarding the basic and primary responsibilities first. If the almost reasonable care regarding developing a certain property will take place, the government will surely be the taxpayer's side as well. Talking about TAN versus FC of the Administrative Appeals Tribunal of Australia, 21 December 2021. TAN was an Australian citizen living in Australia since 1998, and his spouse, Miss Lee, was a Malaysian citizen. None of them had any real property during June 2015 in Australia. Later on in the year 2016, Lee brought a resident in Australia and TAN filed an income tax return. The Government of Australia and Government of Malaysia proposed to have an agreement in terms of avoiding double taxation by TAN on 28 December 2015. Being TAN accepted that in the duration from 1st July 2014 to 31st December 2014, and then 1st April 2015 to 30 June 2015, he is to be treated as a tax resident in Australia, whereas from 1st April 2015 to 30 June 2015, he should be treated as a tax resident of Malaysia. That enlightens clarity to the overall aspect regarding this case according to Australian Taxation Office 2006. One of the bridge section is the Income Tax Assessment Act 1936. This section is an act of the Parliament of Australia under which income tax value is calculated. International Tax Agreement Act 1953 is another violated act of this case which conducts tax agreements among two or more countries due to particular reasons. Income Tax Assessment Act 1997 is another bridge section which is revised act section of tax assessment. Income tax Malaysia is also breached in this particular case, and this act is a Malaysian legislation that imposed income tax value. The court has finally decided that TAN is supposed to pay the residential tax in Australia, and no agreement will be performed by the governments of Malaysia and Australia based on residential tax. As a responsible citizen of the certain country, the people must maintain consistency in paying taxes, including residential tax, income tax, service tax, direct tax, indirect tax, and so on. Before issuing any taxation file, all the aspects of a certain fact should be analyzed thoroughly by that certain applicant. If not possible, then an efficient lawyer should be hired to enlighten on all the present aspects regarding the client's concern. These are the references for my assignment 3 of TAX 600. Thank you.